Colleagues, why don't we take our seats?
The Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Lord, through all the generations, you have been our mighty God. As millions mourn the deaths of Kobe and Gianna Bryant and those who died with them, we think about life's brevity, uncertainty, and legacy. Remind us that we all have a limited time on earth to leave the world better than we found it. As this impeachment process unfolds, give our senators the desire to make the most of their time on earth. Teach them how to live, O God, and lead them along the path of honesty. May they hear the words of Jesus of Nazareth reverberating down the corridors of the centuries, and you shall know the truth, and the truth shall make you free. And Lord, thank you for giving our Chief Justice another birthday. Amen.
Amen. Please join me in reciting the Pledge of Allegiance to our flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Please be seated. If there is no objection, the journal of proceedings of the trial are approved to date. Without objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
Mr. Chief Justice.
The Majority Leader is recognized.
As the chaplain has indicated, on behalf of all of us, a happy birthday. I'm sure this is exactly how you had planned to celebrate the day.
Well, thank you very much for those kind wishes, and thank you to all the senators for not asking for the yays and nays.
And for the information of all senators, we should expect a break every 2 or 3 hours, and then at 6 o'clock, a break for dinner. And with that, Mr. Chief Justice, I yield the floor.
Pursuant to the provisions of Senate Resolution 483, the Counsel for the President have 22 hours and 5 minutes remaining to make the presentation of their case. The Senate will now hear you. Mr. Sekulow.
Thank you, Mr. Chief Justice, members of the Senate, managers. What we've done on Saturday is the pattern that we're going to continue today as far as how we're going to deal with the case. We deal with transcript evidence, We deal with publicly available information. We do not deal with speculation, allegations that are not based on evidentiary standards at all. We are going to highlight some of those very facts we talked about very quickly. On Saturday, you're going to hear more about that. I want to give you a little bit of an overview of what we plan to do today in our presentation. You will hear from a number of lawyers. Each one of these lawyers will be addressing a particular aspect of the president's case. I will introduce the issues that they're going to discuss, and then that individual lawyer will come up and make their presentation. We want to do this on an expeditious but yet thorough basis. Let me start with, just for a very brief few moments, to take a look at where we were. One of the things that became very clear to us as we looked at the presentation from the House managers was the lack of focus on that July 25th transcript. And that's because the transcript actually doesn't say what they would like it to say. Now, we've heard, and you will hear more about that in the days ahead. We know about Mr. Schiff's version of the transcript. You heard it, you saw it. I want to keep coming back to facts. Facts that are really undisputed. The president, in his conversation, was clear on a number of points, but so was President Zelensky. I mentioned that at the close of my arguments earlier, that it was President Zelensky that said, no pressure. I didn't feel any pressure. And again, as this kind of reading of minds of what people were saying, I think we need to look at what they actually said and how it's backed up. It is our position as the President's counsel that the President was at all time acting under his constitutional authority, under his legal authority, in our national interest, and pursuant to his oath of office. Asking a foreign leader to get to the bottom of issues of corruption is not a violation of an oath. It was interesting because there was a lot of discussion the other day about Lieutenant Colonel Vindman, and one of the things that we reiterate is that he himself said he did not know if there was anything of crime or anything of that nature. He had deep policy concerns, and I think that is what this is really about, is deep policy concerns, deep policy differences. But we live in a constitutional republic where you have deep policy concerns and deep differences. That should not be the basis of an impeachment. If the bar of impeachment has now reached that level, then for the sake of the republic, the danger that puts not just this body, but our entire constitutional framework in is unmanageable. Are we going to have every time there's a policy difference of significance or an approach difference of significance about a policy, we're going to start an impeachment proceeding? But, you know, as I said earlier, I don't really think this was about just a phone call. There was a pattern in practice of attempts over a 3-year period to not only interfere with the president's capability to govern, which, by the way, they were completely unsuccessful at. Just look at the state of where we are as a country. But also interfere with our constitutional framework. I'm going to say this, because I want to be brief. We are going to have a series of lawyers address you. So it will not be one lawyer for hours and hours. We're going to have a series of lawyers address you on a variety of issues. This is how we envision the president's defense going. We thought it would be appropriate to start with an overview, if you will, of some of the significant historical issues and constitutional issues involving impeachment proceedings, since we don't have a long history of that, and I think that's good for the country that we don't. And I think we would all agree. But if this becomes the new standard, the future is going to look a lot different. So We're going to hear next from my co-counsel, Judge Kenneth Starr. Judge Starr is a former judge for the U.S. Court of Appeals for the District of Columbia. He served as the 39th Solicitor General of the United States, arguing cases before the Supreme Court of the United States on behalf of the United States. I had the privilege of arguing a case alongside Judge Starr. We were talking about it earlier, many years ago. He also served as the independent counsel during the Clinton presidency and authored the Starr Report. He testified for almost 12 hours before the Judiciary Committee with regard to that report. Judge Starr is very familiar with this process. He is going to address a series of deficiencies. There's legal issues with regard to Articles 1 and 2, constitutional implications, historical implications, and legal implications of where this case now stands. So I would like to yield my time right now to, if it would please, Chief Justice Kenneth Starr.
Mr. Starr.
Thank you, Mr. Chief Justice, House managers, and staff, members of the Senate, the Majority Leader, and the Minority Leader. At the beginning of these proceedings on January 16, the Chief Justice administered the oath of office to the members of this body, and then again on Tuesday. In doing so, the Chief Justice was honoring the words of our Constitution, Article 1, Section 3. We all know the first sentence of that article by heart. The Senate shall have the sole power to try all impeachments. But then the constitutional text goes on to say this: when sitting for that purpose, they shall be on earth oath or affirmation. That oath or affirmation in turn requires each member of the Senate to do impartial justice. Now, this constitutionally administered oath or affirmation has been given in every proceeding in this body since 1798. Indeed, to signify the importance of the occasion, the Senate's more recent traditions call for you, as you did, to sign the book. And that book is not simply part of the record, it's entrusted to the National Archives. In contrast, members of the House of Representatives do not take an oath in connection with impeachment. The framers of our Constitution well knew when an oath or affirmation should be required. The Senate, yes. The House, no. And thus, each member of the world's greatest deliberative body now has special, indeed unique, duties and obligations. Duties imposed under our founding document. During the Clinton impeachment trial 21 years ago in this chamber, the Chief Justice of the United States ruled in response to an objection that was interposed by Senator Tom Harkin of Iowa. The senators are not sitting as jurors, Senator Harkin noted. And the Chief Justice agreed with that proposition. Rather, the Senate is a court. In fact, history teaches us that for literally decades, this body was referred to in this context as the High Court of Impeachment. So we're not in a legislative chamber during these proceedings. We're in a tribunal. We're in court. In Federalist 78, Alexander Hamilton, who's been quoted frequently in these proceedings, but in Federalist 78, he was describing the role of courts, your role. And in doing so, he distinguished between what he called the exercise of judgment, on the one hand, which is what courts do, and the exercise of will or policy preferences, if you will. On the other hand, that's what legislative bodies do. According to Hamilton, courts were to be, in his word, impartial. There's that word again. And that's a daunting task for judges struggling to do the right thing, to be impartial, equal justice under law. It's certainly hard in life to be impartial. In politics, it's not even asked of one to be impartial. But that's the task that the Constitution chose to impose upon each of you. And significantly, in this particular juncture in America's history, the Senate is being called to sit as the high court of impeachment all too frequently. Indeed, we are living in what I think can aptly be described as the age of impeachment. In the House, resolution after resolution, month after month, has called for the president's impeachment. How did we get here? With presidential impeachment invoked frequently in its inherently destabilizing as well as acrimonious way. Briefly told, the story begins 42 years ago. In the wake of the long national nightmare of Watergate, Congress and President Jimmy Carter collaboratively ushered in a new chapter in America's constitutional history. Together, in full agreement, they enacted the independent counsel provisions of the Ethics in Government Act of 1978. But the new chapter was not simply the age of independent counsels. It became, unbeknownst to the American people, the age of impeachment. During my service in the Reagan administration as counselor and chief of staff to Attorney General William French Smith, the Justice Department took the position that, however well-intentioned, the independent counsel provisions were unconstitutional. Why? In the view of the department, those provisions intruded into the rightful domain and prerogative of the executive branch, of the presidency. The Justice Department's position was eventually rejected by the Supreme Court. But most importantly, in helping us understand this new era in our country's history, Justice Antonin Scalia was in deep dissent. Among his stinging criticisms of that law, Justice Scalia wrote this: "The context of this statute is acrid with the smell of threatened impeachment." Impeachment. Justice Scalia echoed the criticism of the court in which I was serving at the time, the District of Columbia Circuit, which had actually struck down the law as unconstitutional, and a very impressive opinion by renowned Judge Lawrence Silberman. Why? Why would Justice Scalia refer to impeachment? This was a reform measure. There would be no more Saturday night massacres, the firing of Special Prosecutor, as he was called, Archibald Cox, by President Nixon. Government would now be better, more honest, greater accountability, and the independent counsel would be protected. But the word impeachment haunts that dissenting opinion, and it's not hard to discover why. Because the statute, by its terms, expressly directed the independent counsel to become, in effect, an agent of the House of Representatives. And to what end? To report to the House of Representatives when a very low threshold of information was received that an impeachable offense left undefined may have been committed. To paraphrase President Clinton's very able counsel at the time, Bernie Nussbaum, this statute is a dagger aimed at the heart of the presidency. President Clinton nonetheless signed the reauthorized measure into law, and the nation then went through the long process known as Whitewater, resulting in the findings by the office which I led, the Office of Independent Counsel, in a written report to the House of Representatives. That referral to Congress was stipulated in the Ethics in Government Act of 1978. To put it mildly, Democrats were very upset about what had happened. They then joined Republicans across the aisle, who for their part had been outraged by an earlier independent counsel investigation, that of a very distinguished former judge, Lawrence Walsh. During the Reagan administration, Judge Walsh's investigation of what became known to the country as Iran-Contra spawned enormous criticism on the Republican side of the aisle, both as to the investigation itself, but also as to the statute. The acrimony surrounding Iran-Contra, and then the impeachment and the trial, and President Clinton's acquittal by this body led inexorably to the end of the independent counsel era. Enough was enough. And living through that wildly controversial 21-year bold experiment with the independent counsel statute, Congress, in a bipartisan way, had a change of heart. It allowed the law to expire in accordance with its terms in 1999. That would-be and well-intentioned reform measure died a quiet and uneventful death, and it was promptly replaced by Justice Department internal regulations promulgated by Attorney General Janet Reno during the waning months of the Clinton administration. One can review those regulations and see no reference to impeachment. None. No longer were the poison pill provisions of presidential impeachment part of America's legal landscape. They were gone. The Reno regulations seemed to signal a return to traditional norms. Impeachment would no longer be embedded in the actual laws of the land, but returned to the language of the Constitution. But in the meantime, America's constitutional DNA and its political culture had changed. Even with the dawn of the new century, the 21st century, impeachment remained on the lips of countless Americans and echoed frequently in the people's house. The impeachment habit proved to be hard to kick. Ironically, while this was happening here at home, across the Atlantic, the use of impeachment as a weapon disappeared. In the United Kingdom, from which, of course, we inherited the process, impeachment was first used more than 2 centuries before those first settlers crossed the Atlantic. But upon thoughtful examination, a number of modern-day parliamentary committees looked and found impeachment to be obsolete. Among other criticisms. Members of Parliament came to the view that the practice, which had last been attempted in Britain in 1868, fails to meet modern procedural standards of fairness. Fairness. As Sir William Mackay recently remarked, impeachment in Britain is dead. Yet here at home, in the world's longest-standing constitutional republic, instead of a once-in-a-century phenomenon, which it had been, presidential impeachment has become a weapon to be wielded against one's political opponent. In her thoughtful Wall Street Journal op-ed a week ago Saturday, Peggy Noonan wrote this: "Impeachment has now been normalized. It won't be a once-in-a-generation act, but an every administration act. Democrats will regret it when Republicans are handing out the pens of the signing ceremony." When we look back down the corridors of time, we see that for almost our first century as a constitutional republic, the sword of presidential impeachment remained sheathed. Had there been controversial presidents? Oh, yes, indeed. Think of John Adams and the Alien and Sedition Acts. Think of Andrew Jackson and Henry Clay. Were partisan passions occasionally inflamed during that first century? Of course. Unless there be any doubt, the early Congresses full well knew how to summon impeachment to the fore, including against a member of this body, Senator William Blount of Tennessee. During the Jefferson administration, the unsuccessful impeachment of Justice Samuel Chase, a surly and partial jurist who was nonetheless acquitted by this chamber, became an early landmark in maintaining the treasured independence of our federal judiciary. It took the national convulsion of the Civil War, the assassination of Mr. Lincoln, and the counter-Reconstruction measures aggressively pursued by Mr. Lincoln's successor, Andrew Johnson, to bring about the nation's very first presidential impeachment. Famously, of course, your predecessors in this high court of impeachment acquitted the unpopular and controversial Johnson, but only by virtue of senators from the party of Lincoln breaking ranks. It was over a century later that the nation returned to the tumultuous world of presidential impeachment, necessitated by the rank criminality of the Nixon administration. In light of the rapidly unfolding facts, including uncovered by the Senate Select Committee, and an overwhelmingly bipartisan vote of 410 to 4, the House of Representatives authorized an impeachment inquiry. And in 1974, the House Judiciary Committee, after lengthy hearings, voted again in a bipartisan manner to impeach the President of the United States. Importantly, President Nixon's own party was slowly but inexorably moving toward favoring the removal of their chosen leader from the nation's highest office, who had just won re-election by a landslide. It bears emphasis before this high court. This was the first presidential impeachment in over 100 years. It also bears emphasis. It was powerfully bipartisan. And it wasn't just the vote to authorize the impeachment inquiry. Indeed, the House Judiciary Chair, Peter Rodino of New Jersey, was insistent that to be accepted by the American people, the process had to be bipartisan. Like war, impeachment is hell, or at least presidential impeachment is hell. Those of us who lived through the Clinton impeachment, including members of this body, full well understand that a presidential impeachment is tantamount to domestic war, albeit thankfully protected by our beloved First Amendment, a war of words and a war of ideas. But it's filled with acrimony, and it divides the country like nothing else. Those of us who lived through the Clinton impeachment understand that in a deep and personal way. Now, in contrast, wisely and judiciously conducted, unlike the United Kingdom, impeachment remains a vital and appropriate tool in our country to serve as a check with respect to the federal judiciary. After all, in the Constitution's brilliant structural design, federal judges know, as this body full well knows from its daily work, a pivotally important feature: independence from politics, exactly what Alexander Hamilton was talking about in Federalist 78. During the Constitution's term, good behavior, in practical effect, life tenure. Impeachment is thus a very important protection for we, the people, against what could be serious Article III wrongdoing within that branch. And so it is that when you count, of the 63 impeachment inquiries authorized by the House of Representatives over our history, only 8 have actually been convicted in this high court and removed from office. And each and every one has been a federal judge. This history leads me to reflect on the nature of your weighty responsibilities here in this high court as judges in the context of presidential impeachment. The 4th presidential impeachment, I'm counting the Nixon proceedings, and our nation's history, but the 3rd over the past half century. And I respectfully submit that the Senate, in its wisdom, would do well in its deliberations to guide the nation in this world's greatest deliberative body to return to our country's traditions when presidential impeachment was truly a measure of last resort. Members of this body can help, and in this very proceeding, restore our constitutional and historical traditions. Above all, by returning to the text of the Constitution itself. It can do so by its example here in these proceedings, in weaving the tapestry of what can rightly be called the common law of presidential impeachment. That's what courts do. They weave the common law. There are indications within the constitutional text, I'll come to our history, that this fundamental question is appropriate to be asked. You're familiar with the arguments. Was there a crime or other violation of established law alleged? So let's turn to the text. Throughout the Constitution's description of impeachment, the text speaks always, without exception, in terms of crimes. It begins, of course, with treason, the greatest of crimes against the state and against we, the people. But so misused as a bludgeon in parliamentary experiences to lead the founders to actually define the term in the Constitution itself. Bribery an iniquitous form of moral and legal corruption, and the basis of so many of the 63 impeachment proceedings over the course of our history. Again, almost all of them against judges. And then the mysterious terms, other high crimes and misdemeanors. Once again, the language is employing the language of crimes. The Constitution is speaking to us in terms of crimes. Each of those references, when you count them, count 7, count 8, supports the conclusion that impeachments should be evaluated in terms of offenses against established law. But especially with respect to the presidency, where the Constitution requires the Chief Justice of the United States, and not a political officer, no matter how honest, no matter how impartial, to preside at trial. Guided by history, the framers made a deliberate and wise choice to cabin, to constrain, to limit the power of impeachment. And so it was on the very eve of the impeachment of President Andrew Johnson. The eminent scholar and dean of the Columbia Law School, Theodore Dwight, wrote this: "The weight of authority is that no impeachment will lie except for a true crime, a breach of the law which would be the subject of indictment." I'm not making that argument. I'm noting what he is saying. He didn't over-argue the case. He said the weight of authority. The weight of authority. And so this issue is a weighty one. Has the House of Representatives, with all due respect, in these 2 articles of impeachment, charged a crime or violation of established law or not? This is, I don't want to over-argue, an appropriate and weighty consideration for the Senate. But especially, as I'm trying to emphasize, in the case not of a federal judge, but of the president. Courts consider prudential factors, and there is a huge prudential factor that this trial is occurring in an election year, when we, the people, in a matter of months, will go to the polls. In developing the common law of presidential impeachment, this threshold factor, consistent with the constitutional text, consistent with the nation's history in presidential impeachments, as I'll seek to demonstrate, serves as a clarifying and stabilizing element. It increases predictability. To do what? To reduce the profound danger that a presidential impeachment will be dominated by partisan considerations, precisely the evil that the framers warned about. And so to history. History bears out the point. The nation's most recent experience, the Clinton impeachment, even though severely and roundly criticized, charged crimes. These are crimes proven in the crucible of the House of Representatives debate beyond any reasonable observer's doubt. So too the Nixon impeachment. The articles charged crimes. What about Article 2 in Nixon, which is sometimes referred to as abuse of power? Was that the abuse of power article? The precursor to Article 1 that is before this court? Not at all. When one returns to Article 2 in Nixon, approved by a bipartisan House Judiciary Committee, Article 2 of Nixon sets forth a deeply troubling story of numerous crimes. Not one, not two, numerous crimes carried out at the direction of the president himself. And so the appropriate question, Were crimes alleged in the articles in the common law of presidential impeachment? In Nixon, yes. In Clinton, yes. Here, no. A factor to be considered as the judges in the high court come, as you will, individually to your judgment. Even in the political cauldron of the Andrew Johnson impeachment, Article 11 charged a violation of the controversial Tenure of Office Act. You're familiar with it. And that act warned expressly the Oval Office that its violation would constitute a high misdemeanor, employing the very language of constitutionally cognizable crimes. This history represents, and I believe, may it please the court, it embodies the common law of presidential impeachment. These are facts gleaned from the constitutional text and from the gloss of the nation's history. And under this view, the commission of an alleged crime or violation of established law can appropriately be considered, again, a weighty and an important consideration, an element of an historically supportable presidential impeachment. Will law professors agree with this? No. But with all due respect to the Academy, this is not an academic gathering. We're in court. We're not just in court. With all due respect to the Chief Justice and the Supreme Court of the United States, we're in democracy's ultimate court. And the better constitutional answer to the question is provided by a rigorous and faithful examination of the constitutional text, and then looking faithfully and respectfully to our history. The very divisive Clinton impeachment demonstrates that while highly relevant, the commission of a crime is by no means sufficient to warrant the removal of our duly elected president. Why? This body knows. We appoint judges and you confirm them, and they're there for life, not presidents. And the presidency is unique. The presidency stands alone in our constitutional framework. Before he became the Chief Justice of the United States, John Marshall, then sitting as a member of the People's House, made a speech on the floor of the House. And there he said this: "The president is the sole organ of the nation and its external relations, and its sole representative with foreign nations." If that sounds like hyperbole, it has been embraced over decades by the Supreme Court of the United States, by justices appointed by many different presidents. The presidency is unique. There's no other system quite like ours, and it has served us well. And so as to the presidency, impeachment and removal not only overturns a national election and perhaps profoundly affects an upcoming election. In the words of Yale's Akhil Amar, it entails a risk, and these are Akhil's words, Professor Amar's words, grave disruption of the government. Professor Amar penned those words in connection with the Clinton impeachment. Grave disruption of the government, regardless of what the president has done. Grave disruption. We will all agree that the presidents, under the text of the Constitution and its amendments, are to serve out their term, absent a genuine national consensus reflected by the two-thirds majority requirement of this court that the president must go away. 2/3. In politics and in impeachment, that's called a landslide. Here, I respectfully submit to the court that all fair-minded persons will surely agree there is no national consensus. We might wish for one, but there isn't. To the contrary, for the first time in America's modern history, not a single House member of the president's party supported either of the two articles of impeachment. Not one. Not in committee, not on the House floor. And that pivotal fact puts in bold relief the Peter Rodino principle. Call it the Rodino rule. Impeachment must be bipartisan in nature. Again, sitting as a court, this body should signal to the nation the return to our traditions, bipartisan impeachments. What's the alternative? Will the president be king? Do oversight. The tradition of oversight, an enormous check on presidential power throughout our history, and it continues available today. In Iran-Contra, no impeachment was undertaken. The Speaker of the House, a Democrat, Jim Wright, from Texas, from Fort Worth, where the West begins, knew better. He said no, but as befits the age of impeachment, a House resolution to impeach President Ronald Reagan was introduced. It was filed. And the effort to impeach President Reagan was supported by a leading law professor whose name you would well recognize, and you will hear it again this evening from Professor Dershowitz. I'll leave it to him to identify the learned professor. But the Speaker of the People's House, echoing Peter Rodino, said no. So I respectfully submit that the Senate should close this chapter, this idiosyncratic chapter, on this increasingly disruptive act, this era, this age of resort to the Constitution's ultimate democratic weapon for the presidency. Let the people decide. There was a great justice who sat for 30 years, Justice John Harlan, in the mid-century of the 20th century. And in a lawsuit involving a very basic question, can citizens whose rights have clearly been violated by federal law enforcement agencies and agents bring an action for damages when Congress has not so provided? No law that gave the wounded citizen a right to redress through damages. And Justice Harlan, in a magnificent concurring opinion in Bivens versus 6 unnamed federal agents, suggested that courts, here you are, should take into consideration in reaching its judgment, their judgment, what he called factors counseling restraint. He was somewhat reluctant to say that we, the Supreme Court, should grant this right, that we should create it when Congress hasn't acted, and Congress could have acted, but it hadn't. But he reluctantly came to the conclusion that the Constitution itself empowered the federal courts to create this right for our injured citizens, to give them redress, not just an injunctive relief, but damages, money recovery for violations of their constitutional rights. Factors counseling restraint. And he addressed them, and he came to the view, and he was so honest and said, I came to the case with a different view. but I changed my mind and voted in favor of the Bivens family having redress against the federal agents who had violated their rights, judging in its most impartial and elegant sense. I'm going to draw from Justice Harlan's matrix of factors counseling restraint and simply identify these. I think there may be others. The articles do not charge a crime or violation of established law. I'm suggesting it's a relevant factor. I think it's a weighty factor when we come to presidential impeachment, not judicial impeachment. Secondly, the articles come to you with no bipartisan support. They come to you as a violation of what I'm dubbing the Rodino rule. And third, as I will now discuss, the pivotally important issue of process. The second article of impeachment, obstruction of Congress. This court is very familiar with United States versus Nixon. Its unanimity in recognizing the president's profound interest in confidentiality, regardless of the worldview or philosophy of the justices were unanimous. This isn't just a contrivance. It's built into the very nature of our constitutional order. So let me comment briefly. This constitutionally based recognition of executive privilege and then companion privileges, the deliberative process privilege, the immunity of close presidential advisors from being summoned to testify, these are all firmly established in our law. If there is a dispute between the People's House and the President of the United States over the availability of documents or witnesses, and there is in each and every administration, then go to court. It really is as simple as that. I don't need to belabor the point. But here's the point I would like to emphasize. Frequently, the Justice Department advises the President of the United States that the protection of the presidency calls whatever the president might want to do as a political matter, as an accommodation and a spirit of comity, to protect privileged conversations and communications. I've heard it in my 2 tours of duty at the Justice Department. Don't release the documents, Mr. President. If you do, you're injuring the presidency. Go to court. We've heard concerns about the length of time that the litigation might take. Those of us who've litigated know that sometimes litigation does take longer than we would like. Justice delayed is justice denied. We would all agree with that. But our history, Churchill's maxim, study history, our history tells us that's not necessarily so. Take by way of example the Pentagon Papers case. Orders issued preventing and sanctioning a gross violation of the First Amendment's guarantee of freedom of the press. An order issued out of the district court June the 15th, 1971. That order was reversed in an opinion by the Supreme Court of the United States 2 weeks later. June the 15th. The House of Representatives could have followed that well-trodden path. It could have sought expedition. The E. Barrett Prettyman Courthouse is 6 blocks down. The judges are there. They're all very able. They're hardworking, people of integrity. Follow the path. Follow the path of the law. Go to court. There would have been at least one problem had the House seen fit to go to court and remain in court. The issue is before you. But among other flaws, the Office of Legal Counsel determined, and I've read the opinion, and I believe it's correct, that with all respect, all House subpoenaed issued prior to the adoption of House Resolution 660, which for the first time authorized the impeachment inquiry as a House. All subpoenas were invalid. They were void. With all due respect to the Speaker of the House of Representatives and all of her abilities and her vast experience, under our Constitution, she was powerless to do what she purported to do. As has been said now time and again, especially throughout the fall, the Constitution does entrust the sole power of impeachment to the House of Representatives. But that's the House. It's 435 members elected from across the constitutional republic. Not one, no matter how able she may be. In the People's House, every congressperson gets a vote. We know the concept: one person, one vote. More generally, the President, as I've reviewed the record, has consistently and scrupulously followed the advice and counsel of the Justice Department, and in particular, the Office of Legal Counsel. He's been obedient. As you know, that important office, many of you have had your own experiences professionally with that office, is staffed with lawyers of great ability. It has a reputation for superb work. It has done such thoughtful work in both Democratic and Republican administrations. And the office is now headed by a brilliant lawyer who served as a law clerk to Justice Anthony Kennedy. The House may disagree with the guidance provided to the President by that office. The House frequently does disagree. But for the President to follow the guidance of the Department of Justice with respect to an interbranch legal and constitutional dispute cannot reasonably be viewed as an obstruction, and most emphatically not as an impeachable offense. History, once again, is a great teacher. In the Clinton impeachment, the House Judiciary Committee rejected a draft article asserting that President Clinton, and here are the words of the draft article, fraudulently and corruptly asserted executive privilege. Strong words. Fraudulently and corruptly. That was the draft article. In my view, having lived through the facts, and with all due respect to the former president, he did. He did it time and again, month after month. We would go to court. We would win. And many members, not everybody, on the House Judiciary Committee agreed that the president had indeed improperly claimed executive privilege, rebuffed time and again by the judiciary. But at the end of the day, that committee, chaired, the Judiciary Committee of the House, chaired by Henry Hyde, wisely concluded that President Clinton's doing so should not be considered an impeachable offense. Here's the idea. It is not an impeachable offense for the President of the United States to defend the asserted legal and constitutional prerogatives of the presidency. This is, and I'm quoting here from page 55 of the President's trial brief, a function of his constitutional and policy judgments. Not just a policy judgment, but a constitutional judgment. I would guide this court as it's coming through the deliberation process to read the President's trial brief with respect to process. It was Justice Felix Frankfurter, confidant of FDR, brilliant jurist, who reminded America that the history of liberty is in large measure the history of process, of procedure. In particular, I would guide the High Court to the discussion of the long history of the House of Representatives, over 2 centuries, in providing due process protections in its impeachment investigations. It's a richly historical discussion. The good news is you can read the core of it in 4 pages, pages 62 to 66 of the trial brief. Puts in bold relief, I believe, an irrefutable fact. This House of Representatives, with all respect, saw fit to turn its back on its own established procedures. Procedures that had been followed faithfully decade after decade, regardless of who was in control, regardless of political party. All those procedures were torn asunder. And all over the vigorous objections from the unanimous and vocal minority. I need not remind this High Court that in this country, minority rights are important. Minority rights should be protected. Equal justice. But then again, the House members took no oath to be impartial. The Constitution didn't require them to say, by oath or affirmation, that we'll do impartial justice. When they chose to tear asunder their procedures, they were oathless. They could toss out their own rule book, raw power. And here we have, tragically for the country, and I believe tragically for the House of Representatives, in Article 2 of these impeachment articles, a runaway House. It has run away, not only from its long-standing procedures, it has run away from the Constitution's demand of fundamental fairness, captured in those hallowed terms, due process of law. We've cared about this as an English-speaking people since Magna Carta. By doing so, however, the House has inadvertently pointed this court to an exit ramp. It's an exit ramp provided by the Constitution itself. It's an exit ramp built by the most noble of builders, the founding generation. Despite the clearest precedent requiring due process for the accused in an impeachment inquiry, but surely all the more so in a presidential impeachment, House Democrats chose to conduct a wholly unprecedented process in this case. And they did so knowingly and deliberately because they were warned at every turn. Don't do it. Don't do it that way. And process. The president being denied the basic rights that have been afforded to every single accused president in the history of the Republic, even to the racist Andrew Johnson, seeking to undo Mr. Lincoln's great legacy. He got those rights, but not here. Due process could have been honored. Basic rights could have been honored. The House rules, the House's traditions could have been honored. But what's done is done. These two articles come before this court, this high court of impeachment dripping with fundamental process violations. When courts, and you're the court, are confronted with this kind of phenomenon, a train of fairness violations, courts in this country do the right thing. They do impartial justice. They invoke, figuratively or literally, the words of the preamble to America's Constitution. The very first order of our government, after to form a more perfect union, is to establish justice. To establish justice. Even before getting to the words to provide for the common defense, to promote the general welfare, to ensure domestic tranquility, the Constitution speaks in terms of justice, establishing justice. Courts would not allow this. They would not allow this because why? They knew and they know that the purpose of our founding instrument is to protect our liberties, to safeguard us, but to safeguard us as individuals against the powers of government. And why? In the benedictory words of the preamble, to secure the blessings of liberty to ourselves and our posterity. Liberty under law. I thank the court.
Mr. Sekulow?
Mr. Chief Justice, members of the Senate, House managers, Judge Starr laid out before you the solemn nature of these proceedings. I want to contrast the solemn nature of these proceedings and what has been laid out before us from a both historical and constitutional perspective. And I want you to think about this: the history, the importance, the solemnity of what we're engaged in here in this great body, with what took place in the House of Representatives upon the signing of articles of impeachment. Pens distributed to the impeachment managers. A celebratory moment. Think about that. Think about this. A poignant moment. We're next going to address a factual analysis. To briefly reflect, my colleague, the Deputy White House Counsel, Mike Papura, will be joining us in a moment to discuss more of the facts, to continue the discussion that we had on Saturday. But let me just recap very quickly what was laid out on Saturday. First, the transcript shows that the president did not condition either security assistance or a meeting on anything. The paused security assistance funds aren't even mentioned on the call. Second, President Zelensky and other Ukrainian officials repeatedly said there was no quid pro quo and no pressure on them to review anything. Third, President Zelensky and high-ranking Ukrainian officials did not even know the security assistance was paused till the end of August, over a month after the July 25th call. Fourth, not a single witness testified that the president himself said that there was any connection between any investigation and security assistance a presidential meeting, or anything else. Fifth, the security assistance flowed on September 11th, and a presidential meeting took place on September 25th without Ukrainian government announcing any investigations. Finally, in the blind drive to impeach the president, President Trump, in reality, strategically, has been the best friend and supporter of Ukraine, certainly in our recent history. These are the facts. That is what's before you. Deputy White House Counsel Mike Popora will now address additional facts related to these proceedings. Thank you.
Mr. Chief Justice, members of the Senate, good afternoon. Mr. Leader, I believe that we will be ready to take a break at the conclusion of my remarks if it meets with your approval. On Saturday, we walked through some of the evidence that the House managers put forward and didn't put forward during their 21-plus hours of presentation. That evidence that we recounted was drawn directly from the House manager's own record. The case they chose to submit to this chamber. To echo my colleague, Mr. Sekulow, briefly, the House manager's own evidence shows that President Trump did not condition anything on investigations during the July 25 call with President Zelensky and did not even mention the paused security assistance on the call. President Zelensky said that he felt no pressure on the call. President Zelensky and the top Ukrainian officials did not learn of the pause on the security assistance until more than a month after the July 25 call. And the House manager's own record, their record that they developed and brought before this chamber, reflects that anyone who spoke with the president said that the president made clear that there was no linkage between security assistance and investigations. There's another category of evidence demonstrating that the pause on security assistance was distinct and unrelated to investigations. The president released the aid without the Ukrainians ever announcing any investigations or undertaking any investigations. Here is Ambassador Sondland.
And the fact is, the aid was given to Ukraine without any announcement of new investigations.
That's correct.
And President Trump did, in fact, meet with President Zelensky in September at the United Nations, correct?
He did.
And there was no announcement of investigations before this meeting?
Correct.
And there was no announcement of investigations after this meeting?
That's right.
So while the security assistance was paused, the administration did precisely what you would expect. It addressed President Trump's concerns about the two issues that I mentioned on Saturday: burden sharing and corruption. A number of law and policy makers also contacted the president and the White House to provide input on the security assistance issue during this period, including Senator Lindsey Graham. The process culminated on September 11, 2019. On that day, the president spoke with Vice President Pence and Senator Rob Portman. The vice president, in NSC Senior Director Tim Morrison's words, was armed with his conversation with President Zelensky from their meeting just days earlier in Warsaw, Poland, and both the Vice President and Senator Portman related their view of the importance of the assistance to Ukraine and convinced the President that the aid should be dispersed immediately. After the meeting, President Trump terminated the pause and the support flowed to Ukraine. I want to take a step back now and talk for a moment about why the security assistance was briefly paused. Again, in the words of the House manager's own witnesses. Witness after witness testified that confronting Ukrainian corruption should be at the forefront of United States foreign policy toward Ukraine. They also testified that the president had long-standing and sincere concerns about corruption in Ukraine. The House managers, however, told you that it was laughable to think that the president cared about corruption in Ukraine. But that's not what the witnesses said. According to Ambassador Volker, President Trump demonstrated that he had a very deeply rooted negative view of Ukraine based on past corruption. And that's a reasonable position, according to Ambassador Volker. Most people who know anything about Ukraine would think that. And Dr. Hill testified, I think the president has actually quite publicly said that he was very skeptical about corruption in Ukraine. And in fact, he's not alone, because everyone has expressed great concerns about corruption in Ukraine. The House managers have said that the president's concern with corruption is disingenuous. They said that President Trump didn't care about corruption in 2017 or 2018, and he certainly didn't care about it in 2019. That was their words. Not according to Ambassador Yovanovitch, however, who testified that President Trump shared his concern about corruption directly with President Poroshenko, President Zelensky's predecessor, in their first meeting in the Oval Office. When was that meeting? In June of 2017. 2017. The president also has well-known concerns about foreign aid generally. Scrutinizing and in some cases curtailing foreign aid was a central plank of his campaign platform. President Trump is especially wary of sending American taxpayer dollars abroad when other countries refuse to pitch in. Mr. Morrison and Mr. Hale both testified at length about President Trump's long-standing concern with burden sharing in foreign aid programs. Here's what they said.
The president was concerned that the United States seemed to bear the exclusive brunt of security assistance to Ukraine. He wanted to see the Europeans step up and contribute more security assistance.
We've often heard at the State Department that the President of the United States wants to make sure that foreign assistance is reviewed scrupulously to make sure that it's truly in U.S. national interests and that we evaluate it continuously so that it meets certain criteria that the President's established.
And has the President expressed that he expects our allies to give their fair share of foreign aid, as evidenced by a point that he raised during the July 25th phone call with President Zelensky to that effect?
The principle of greater burden sharing by allies and other like-minded states is an important element of the foreign assistance review.
The President expressed these precise concerns to Senator Ron Johnson, who wrote, "He reminded me how thoroughly corrupt Ukraine was and again conveyed his frustration that Europe doesn't do its fair share of providing military aid." The House managers didn't tell you about this. Why not? And President Trump was right to be concerned that other countries weren't paying their fair share. As Laura Cooper testified, U.S. contributions to Ukraine are far more significant than any individual country, and she also said EU funds tend to be on the economic side rather than for defense and security. Senator Johnson also confirmed that other countries refuse to provide the lethal defensive weapons that Ukraine needs in its war with Russia. Please keep in mind also that the pause of the Ukraine Security Assistance Program was far from unusual or out of character for President Trump. The American people know that the president is skeptical of foreign aid and that one of his top campaign promises and priorities in office has been to avoid wasteful spending of American taxpayer dollars abroad. Meanwhile, the same people who today claim that President Trump was not genuinely concerned about burden sharing were upset when, as a candidate, President Trump criticized free riding by NATO members. This past summer, the administration paused, reviewed, and in some cases canceled hundreds of millions of dollars in foreign aid to Afghanistan, El Salvador, Honduras, Guatemala, and Lebanon. And these are just some of the reviews of foreign aid undertaken at the very same time that the Ukraine aid was paused. So what happened during the brief period of time while the Ukraine security assistance was paused? People were gathering information and monitoring the facts on the ground in Ukraine as the new parliament was sworn in and began introducing anti-corruption legislation. Notwithstanding what the House managers would have you believe, the reason for the pause was no secret within the White House and the agencies. According to Mr. Morrison, in a July meeting attended by officials throughout the executive branch agencies, the reason provided for the pause by a representative of the Office of Management and Budget was that the president was concerned about corruption in Ukraine, and he wanted to make sure that Ukraine was doing enough to manage that corruption. In fact, as Mr. Morrison testified, by Labor Day, there had been definitive developments to demonstrate that President Zelensky was committed to the issues he campaigned on, anti-corruption reforms. Mr. Morrison also testified that the administration was working on answering the president's concerns regarding burden sharing. Here's Mr. Morrison.
Was there any interagency activity, whether it be with the State Department or the Defense Department, and coordination by the National Security Council to look into that a little bit for the president?
We were surveying the data to understand who was contributing what and sort of in what categories.
And so the president's evinced concerns, the interagency tried to address them?
Yes.
How else do we know that the president was awaiting information on burden sharing and anti-corruption efforts in Ukraine before releasing the security assistance? Because that's what Vice President Pence told President Zelensky. On September 1, 2019, Vice President Pence met with President Zelensky. President Trump was scheduled to attend the World War II commemoration in Poland, but instead remained in the U.S. to manage the emergency response to Hurricane Dorian. Remember, this was 3 days after President Zelensky learned through the Politico article about the review of the security assistance. Just as Vice President Pence and his aides anticipated, Jennifer Williams testified that once the cameras left the room, the very first question that President Zelensky had was about the status of the security assistance. The vice president responded by asking about two things: burden sharing and corruption. Here's how Jennifer Williams described it. The VP responded by really expressing our ongoing support for Ukraine, but wanting to hear from President Zelensky, what the status of his reform efforts were that he could then convey back to the president, and also wanting to hear if there was more that European countries could do to support Ukraine. Vice President Pence knows President Trump, and he knew what President Trump wanted to hear from President Zelensky. The vice president was echoing the president's two recurring themes: corruption and burden sharing. It's the same consistent themes every time. Ambassador Taylor received a similar readout of the meeting between the vice president and President Zelensky, including the vice president's focus on corruption and burden sharing. Here's Ambassador Taylor.
On the evening of September 1st, I received a readout of the Pence-Zelensky meeting over the phone from Mr. Morrison, during which he told me that President Zelensky had opened the meeting by immediately asking Vice President about the security cooperation. The Vice President did not respond substantively, but said that he would talk to President Trump that night. The Vice President did say that President Trump wanted the Europeans to do more to support Ukraine and that he wanted the Ukrainians to do more to fight corruption.
On September 11, based on the information collected and presented to President Trump, the President lifted the pause on the security assistance. As Mr. Morrison explained, our process gave the President the confidence he needed to approve the release of the security sector assistance. The House managers say that the talk about corruption and burden sharing is a ruse. No one knew why the security assistance was paused, and no one was addressing the President's concerns with Ukrainian corruption and burden sharing. The House managers' own evidence, their own record, tells a different story, however. They didn't tell you about this. Not in 21 hours. Why not? The President's concerns were addressed in the ordinary course. The President wasn't caught, as the House managers allege. The managers are wrong. All of this, together with what we discussed on Saturday, demonstrates that there was no connection between security assistance and investigations. When the House managers realized that their quid pro quo theory on security assistance was falling apart, they created a second, alternative theory. According to the House managers, President Zelensky desperately wanted a meeting at the White House with President Trump, and President Trump conditioned that meeting on investigations. So what about the managers' backup accusations? Do they fare any better than their quid pro quo for security assistance? No. No, they don't. A presidential-level meeting happened without any preconditions at the first available opportunity in a widely televised meeting at the United Nations General Assembly in New York on September 25, 2019. The White House was working to schedule the meeting earlier at the White House or in Warsaw, but those options fell through due to normal scheduling and a hurricane. The two presidents met at the earliest convenience without President Zelensky ever announcing or beginning any investigations. The first thing to know about the alleged quid pro quo for a meeting is that by the end of the July 25 call, the President had invited President Zelensky to the White House on 3 separate occasions, each time without any preconditions. President Trump invited President Zelensky to an in-person meeting on their initial April 21 call. When you're settled in and ready, I'd like to invite you to the White House. On May 29, the week after President Zelensky's inauguration, President Trump sent a congratulatory letter, again inviting President Zelensky to the White House. As you prepare to address the many challenges facing Ukraine, please know that the American people are with you and are committed to helping Ukraine realize its vast potential. To help show that commitment, I would like to invite you to meet with me at the White House in Washington, D.C., as soon as we can find a mutually convenient time. Then, on July 25th, President Trump personally invited President Zelensky to participate in a meeting for a third time. Whenever you would like to come to the White House, feel free to call. Give us a date, and we'll work that out. I look forward to seeing you. That's 3 separate invitations for a meeting, all made without any preconditions. During this time, and behind the scenes, the White House was working diligently to schedule a meeting between the presidents at the earliest possible date. Tim Morrison, whose responsibilities included helping arrange head of state visits to the White House or other head of state meetings, testified that he understood that arranging the White House visit with President Zelensky was a do-out that came from the president. The House managers didn't mention the work that the White House was doing to schedule the meeting between President Trump and President Zelensky, did they? Why not? Scheduling a presidential meeting takes time. Mr. Morrison testified that his directorate, which was just one of several, had a dozen schedule requests in with the president for meetings with foreign leaders that we were looking to land, and Ukraine was but one of those requests. Due to both presidents' busy schedules, according to Mr. Morrison, it became clear that the earliest opportunity for the 2 presidents to meet would be in Warsaw at the beginning of September. The entire notion that a bilateral meeting between President Trump and President Zelensky was somehow conditioned on a statement about investigations is completely defeated by one straightforward fact. A bilateral meeting between President Trump and President Zelensky was planned for September 1 in Warsaw, the same Warsaw meeting we were just discussing, without the Ukrainians saying a word about investigations. As it turned out, President Trump was not able to attend the meeting in Warsaw because of Hurricane Dorian. President Trump asked Vice President Pence to attend in his place. But even that scheduling glitch did not put off their meeting for long. President Trump and President Zelensky met at the next available date, September 25, on the sidelines of the United Nations General Assembly. As President Zelensky himself has said, there were no preconditions for his meeting with President Trump. Those are his words. No conditions. So, you're probably wondering, how could the House managers claim that there was a quid pro quo for a meeting with President Trump when the 2 presidents actually did meet without President Zelensky announcing any investigations? Well, the House managers moved the goalposts again. They claimed that the meeting couldn't be just an in-person meeting with President Trump. What it had to be was a meeting at the Oval Office and in the White House. That's nonsense. Putting to one side the absurdity of the House managers trying to remove a duly elected President of the United States from office because he met a world leader in one location versus another, this theory has no basis in fact. As Dr. Hill testified, what mattered was that there was a bilateral presidential meeting, not the location of the meeting. She said, it wasn't always a White House meeting per se, but definitely a presidential level, meeting with Zelensky and the president. I mean, it could have taken place in Poland, in Warsaw. It could have been, a proper bilateral in some other context. But in other words, a White House level presidential meeting. The House managers didn't tell you about Dr. Hill's testimony. Why not? In fact, they said just last week that President Zelensky still hasn't gotten his White House meeting. Why didn't they tell you about Dr. Hill's testimony? So you would have the full context and information. They spoke for over 21 hours. They couldn't take a couple of minutes to give you that context? How else do we know that Dr. Hill was right? Because President Zelensky said so on the July 25 call. Remember, when President Trump invited President Zelensky to Washington on the July 25 call, President Zelensky said he would be happy to meet with you personally and offered to host President Trump in Ukraine, or, on the other hand, meet with President Trump on September 1 in Poland. That's exactly what the administration planned to do. If it weren't for Hurricane Dorian, President Trump would have met with President Zelensky in Poland on September 1, just as President Zelensky had requested, and without any preconditions. As it happened, President Zelensky met with the Vice President instead, and just a few weeks later, met with President Trump in New York, all without anyone making any statement about any investigations. And once again, not a single witness in the House record that they compiled and developed under their procedures that we've discussed and will continue to discuss provided any firsthand evidence that the president ever linked a presidential meeting to any investigations. The House managers have seized upon Ambassador Sondland's claim that Mr. Giuliani's requests were a quid pro quo for arranging a White House visit for President Zelensky. But again, Ambassador Sondland was only guessing based on incomplete information. He testified that the president never told him that there was any sort of a condition for a meeting with President Zelensky. Why then did he think there was one? In his own words, Ambassador Sondland said that he could only repeat what he heard through Ambassador Volker from Giuliani. So he didn't even hear from Mr. Giuliani himself. But Ambassador Volker, who is the supposed link between Mr. Giuliani and Ambassador Sondland, thought no such thing. Ambassador Volker testified unequivocally that there was no linkage between the meeting with President Zelensky and Ukrainian investigations. I'm going to read the full questions and answers because this passage is key. This is from Ambassador Volker's deposition testimony. Question: did President Trump ever withhold a meeting with President Zelensky or delay a meeting with President Zelensky until the Ukrainians committed to investigate the allegations that you just described concerning the 2016 presidential election? Answer: the answer to the question is no, if you want a yes or no answer, but the reason the answer is no is we did have difficulty scheduling a meeting, but there was no linkage like that. Question: you said that you were not aware of any linkage between the delay in the Oval Office meeting between President Trump and President Zelensky and the Ukrainian commitment to investigate the two allegations as you described them, correct? Answer: correct. On no fewer than 15 separate occasions over the past week, the House managers played a video of Ambassador Sondland saying that the announcement of the investigations was a prerequisite for a meeting or call with the president. 15 times. They never once read to you the testimony that I just did. They never once read to you the testimony in which Ambassador Volker refuted what Ambassador Sondland claimed he heard from Ambassador Volker. So here's what we know. President Trump invited President Zelensky to meet 3 times without preconditions. The White House was working behind the scenes to schedule the meeting. The two presidents planned to meet in Warsaw, just as President Zelensky had asked, and ultimately met 3 weeks later without Ukraine announcing any investigations. No one testified in the House record that the president ever said there was a connection between a meeting and investigations. Those are the facts, plain and simple. So much for a quid pro quo for a meeting with the president. Before I move on, let me take a brief moment to address a side allegation that was raised in the original whistleblower complaint and that the House managers are still trying to push. The managers claim that President Trump ordered Vice President Pence not to attend President Zelensky's inauguration in favor of a lower-ranking delegation, in order, according to them, to signal a downgrading of the relationship between the United States and Ukraine. That's not true. Numerous factors had to align, as I'm sure everyone in this room can greatly appreciate, for the Vice President to attend. First, dates of travel were limited. For national security reasons, the President and Vice President generally avoid being out of the country at the same time for more than a few hours. The President had scheduled trips to Europe and Japan during the period when our embassy in Ukraine anticipated the Ukrainian inauguration would occur at the end of May or in early June. Jennifer Williams testified that the Office of the Vice President advised the Ukrainians that if the Vice President were to participate in the inauguration, the ideal dates would be around May 29, May 30, May 31, or June 1, when the President would be in the United States. She said, if it wasn't one of those dates, it would be very difficult or impossible for the Vice President to attend. Second, the House managers act as if no other priorities in the world could compete for the administration's time. The Vice President's office was simultaneously planning a competing trip for May 30 in Ottawa, Canada, to participate in an event supporting passage of the United States-Mexico-Canada agreement. Ultimately, the Vice President traveled to Ottawa on May 30 to meet with Prime Minister Justin Trudeau and to promote the passage of the USMCA. This decision, as you know, advanced a top administration priority and an issue President Trump vigorously supported. What you did not hear from the House managers was that the Ukrainian inauguration dates did not go as planned. On May 16, the Ukrainians surprised everyone and scheduled the inauguration for just 4 days later, on May 20, Monday, May 20. So think about that, May 16, May 20. Get everybody, security, advance, everyone to Ukraine. Jennifer Williams testified that it was very short notice, so it would have been difficult for the Vice President to attend, particularly since they hadn't sent out the advance team. George Kent testified that the short notice left almost no time for either proper preparations or foreign delegations to visit, and that the State Department scrambled on Friday, the 17th, to try and figure out who was available. Mr. Kent suggested that Secretary of Energy Perry be the anchor for the delegation as someone who is a person of stature and whose job had relevance to our agenda. Secretary Perry led the delegation, which also included Ambassador Sondland, Ambassador Volker, and Senator Johnson. Ambassador Volker testified that it was the largest delegation from any country there, and it was a high-level one. The House managers didn't tell you this. Why not? The claim that the President instructed the Vice President not to attend President Zelensky's inauguration is based on House manager assumptions with no evidence that the President did something wrong. And finally, as I'm coming to the end, if the evidence doesn't show a quid pro quo, what does it show? Unfortunately for the House managers, one of the few things that all of the witnesses agreed on was that President Trump has strengthened the relationship between the U.S. and Ukraine, and that he has been a more stalwart friend to Ukraine and a more fierce opponent of Russian aggression than President Obama. The House managers repeatedly claimed that President Trump doesn't care about Ukraine. They are attributing views to President Trump that are contrary to his actions. More importantly, they are contrary to the House managers' own evidence. But don't take my word for it. Ambassadors Yovanovitch, Taylor, and Volker all testified to the Trump administration's positive new policy toward Ukraine based especially on President Trump's decision to provide lethal aid to Ukraine. Ambassador Taylor testified that President Trump's policy toward Ukraine was a substantial improvement over President Obama's policy. Ambassador Volker agreed that America's policy towards Ukraine has been strengthened under President Trump, whom he credited with approving each of the decisions made along the way. Ambassador Yovanovitch testified that President Trump's decision to provide lethal weapons to Ukraine meant that our policy actually got stronger over the last 3 years. She called the policy shift that President Trump directed very significant. Let's hear from Ambassador Taylor, Ambassador Volker, and Ambassador Yovanovitch.
The Trump administration has indeed provided substantial aid to Ukraine in the form of defensive lethal aid, correct?
That is correct.
And that is more so than the Obama administration, correct?
The Trump
Defensive lethal aid.
Yes.
President Trump approved each of the decisions made along the way, providing lethal defensive equipment.
And the Trump administration strengthened our policy by approving the provision to Ukraine of anti-tank missiles known as javelins. They are obviously tank busters, and so if the war with Russia all of a sudden accelerated in some way and tanks come over the horizon, javelins are a very serious weapon to deal with that.
Ukraine is better positioned to fight Russia today than it was before President Trump took office. As a result, the United States is safer too. The House managers did not tell you about this testimony from Ambassadors Taylor, Volker, and Yovanovitch. Why not? These are the facts, as drawn from the House managers' own record on which they impeached the president. This is why the House managers' first article of impeachment must fail, for the 6 reasons I set forth when I began on Saturday. There was no linkage between investigations and security assistance or a meeting on the July 25 call. The Ukrainians said there was no quid pro quo and they felt no pressure. The top Ukrainians did not even know that security assistance was paused until more than a month after the July 25 call. The House manager's record reflects that anyone who spoke with the president said that the president made clear that there was no linkage. The security assistance flowed and the presidential meeting took place, all without any announcement of investigations, and President Trump has enhanced America's support for Ukraine in his 3 years in office. These facts all require that the first article of impeachment fail. You have already heard and will continue to hear from my colleagues on why the second article must fail. Once again, this is the case that the House managers chose to bring. This is the evidence they brought before the Senate. The very heavy burden of proof rests with them. They say their case is overwhelming and uncontested. It is not. They say they have proven each of the articles against President Trump. They have not. The facts and evidence of the case the House managers have brought exonerate the president. Thank you for your attention. And I think we're ready for a break.
The majority leader is recognized.
Justice, colleagues will take a 15-minute break.
Without objection.